Any mention?
Yes.
Mention is
Lordship, I beg to make a small mention, my lord. There is a pending matter, an appeal. Mr. Ramaswamy, TSG from Delhi, had appeared on the last occasion. He was online just now, just to make a mention. Sorry. Sorry.
Mr. Venkatraman.
Sorry. My mistake.
My lord heard the matter and posted it for 26th July, but the Lordship's court did not assemble that day.
Yes.
Will the Lordship be kind to hear it?
26 I appeared online. Right. We conducted the proceedings online. Not on 26. Must be
23rd. Sorry, 23rd.
Yes.
23rd. Sorry, I made a mistake. My mistake.
Yes. Yes.
Will your Lordship have it, my lord? A very short point. Will your Lordship have it on August 5th, Monday, my lord? We'll complete it.
We'll see. We'll take the bundle. We'll see. Yes.
As a please.
from the daily list. Item 1.
The delay of 50 days. 50 days delay. No.
Lordship, that
Yes, delay is control. What is the matter about?
Lordship, right before I start with the main case, Lordship, there is one more in this case, MCWA 22, that is pending, Lordship, because I filed an application to leave to file this appeal, Lordship. Because what happened is because that after the passing of the impute order judgment passed by the single judge, the main petitioner expired, Lordship. Therefore, we have filed this particular person who is have filed this application. They are agreed by the leave to file an application because that person who was in the repetition, he expired after the passing of the order by the London single bench, Lordship.
What is it?
We have no objection for 1, 2, and 3, Lordship. Private respondents are there.
Notice to the private respondents. Notice go.
Lordship.
Who died?
The main petitioner is Tasing.
The original
He was
petitioner before
petitioner before the Lordship. He was the petitioner in repetition 2, 3, 3.
No, where is the man of there? What is the application number?
Application number is MCWA 2020.
No, application for?
Leave to file. Leave to file.
Leave to file. What do you mean by leave to file?
Leave to file.
Already filed.
Yes, already filed.
Already case has been filed, sir.
Lordship.
Delay has been condoned.
Lordship.
Main case has been numbered.
Lordship.
One person died means you have to substitute the person who was diseased. You have to file a petition for substitution. So once again you are seeking leave. What leave you require? If a person dies, the legal hands of somebody will have to be with the public interest litigation. Is different thing. Any person can come.
Yes, Lordship. Correctly, Lordship has corrected. It has been the substitution. Yes.
Yes.
Yes, Lordship. So that now the main case here is that
That is a substitution petition. Where is the substitution petition?
actually instead of that one, I have filed the application.
Can't be like that.
Application.
You have to file a petition for substitution. What do you mean by leave? How many times we can give leave?
Usually, practically, what happened earlier, we did that is a practice, Lordship.
You will have to file a petition for substitution. One person dies means how can we say give leave?
Yes. Lordship, maybe just then allow me to just file small.
Yes, you file a petition.
Lordship.
It is represented that the main petition, the first, which petition? First petitioner.
Yes, there is only one petitioner.
One petitioner.
Yes. The impute order.
It is represented that the writ petitioner who is an appellant is no more.
Lordship.
And the petitioner is seeking leave of this court to permit the wife of the deceased to file a petition.
It's not a wife, it's a relative.
Relative.
Yes, nephew. Niece. The petitioner coming here, the niece and the husband of the niece, because as per the Gulf customary law, the grandson and the daughter of youngest daughter, he is the youngest daughter of that deceased.
So and so has filed,
Lordship.
and the petition is seeking leave. We are not inclined to accept the grant the leave as prayed for, and it is for the petitioner to file a necessary petition to substitute
Lordship.
the legal heirs of the deceased. When we reject the application MC 23 of 2024, permission is granted to file a petition for substitution.
Lordship. Lordship. Obliged. Much obliged, Lordship.
Item number 2.
Para 9.
Para 9 of your order.
1 minute. Case the company there was
It
no
was the
real
case
income
of the
accrued.
company
Yes.
that there was the real income accrued, and in fact the income accrued was only hypothetical. Now
Huh?
thereafter, as the transaction recorded, thereafter the problem is as the transaction recorded under the advance license or under the duty and title passbook,
Oh,
these facts are related to the case law relied upon. It was on late payment surcharge.
what is he saying? What is his argument? Clear. This is not clear, sir. Mr. Jain, sorry, your voice is
My-
not clear.
Yes, can you hear me?
Yes,
Your Lordship,
yes,
Can you hear me?
yes.
No, Your Lordship.
We are having para number 9.
Yes, it was the case of the company that there was no real income accrued to the company, and in fact the income accrued was only hypothetical. This is correct. But thereafter, as the transaction recorded under the advance license or under the duty entitlement, this was not my case. This was the case relied upon on Excel Industry, which Your Lordship quoted. My case was for late payment surcharge on delayed payment.
So,
Then Your Lordship
no,
has to
no,
substitute
which
these
are the
words.
words which are incorporated, which are
As
not
the
required,
transaction report-
as a transaction
Not required,
recorded on the above licenses.
or under the duty entitlement.
No, up to hypothetical is correct.
Yes. And then Your Lordship can delete these words in between up to passbook.
From where?
As the transaction recorded under the advance license or under the duty entitlement passbook. Your Lordship can delete this word.
Oh, this one, huh? Okay.
Yeah. And add late payment surcharge instead thereof.
Huh? Sir?
Please add the word late payment surcharge. Late payment surcharge. Because my case was that this is the late payment interest which was not recoverable. So it was Your Lordship may add only hypothetical, as the late payment surcharge do not represent the real income of the cessee.
As late payment surcharge do not represent the real income. Was only
Yes, Your Honor.
as madam, corrected, sir. Yeah.
And then para 5, another is para 5, Lordship.
Para 5. So you are re-arguing the case, yes. Para 5, yes.
Learned counsel for the department further submitted that the method of late payment surcharge on case basis had all along been followed by the company from year to year 2003-4, and similar views of accepting such method of LLP on cash basis, even when the books of accounts are maintained or mercantile, have been recognized through various judicial pronouncements. Therefore, the order of reassessment made by the assessing officer is neither erroneous nor prejudicial to the interest of the department, and the order tribunal warrants no interference by this court. So these were my arguments. These were not the argument of the department. So Your Lordship should say in the beginning learned counsel for the company instead of saying for the department.
Oh, it should be department. Instead of department, it should be company. The other cause of the
Yes.
submitted
And then
that.
thereafter,
No, instead of department, it should be company.
yes, and then a word no has to be added before the warrants, after the warrants.
Where is it? Is it?
Neither erroneous or nor prejudicial to the interest of the company, and the order of the tribunal warrants no interference.
Where is it?
If you want to see this
Oh,
eighth
yeah.
line, ninth line.
Where is it?
Lordship, 9th line, Lordship, 5th paragraph.
Yes. Petitioner to the attention.
That's all, your lord. Yes, sir.
The petition to the attention of the court to the typographical error in the order in para number 5 and 9. What is it? The department is not the department case. It's a police case. Which on the other side? What is it, sir?
Lordship, no objection, Lordship.
Also, the respondent has also no objection in making those corrections. So registry is directed to fresh order. Okay, I marked it here. Para number 5 and para number 9. Yes.
Deeply obliged, Lordship.
Oblige, your lordship.
Item number 3.
Yes. Yes.
My lords, item number 3 and 4 arises from the same judgment of the learned single judge. May I pray, my lord, may kindly take up item number 4, my lord.
Item number 4, madam. 27.
Lord, I must indicate there is a delay of 13 days, my lord.
Who's on the side? Yes. No objection.
I'm appearing for 1 and 2.
That's why no objection. Delay condom. Registry is there to number the appeal and list it tomorrow.
And caveat can be richer, sir. I have filed caveat.
Yes, we'll hear you. Your name will also be printed. Your name is printed here? Yes.
My lord, only our anxiety was subject to your lordship's kind consideration. And because there is now, earlier there was a stay order when the proceeding was pending before the learned single judge. Now the writ petition has been dismissed. The authority might go ahead with the, invoking the
We
demand.
hope tomorrow you will not pass orders.
That's
They will come up for admission tomorrow.
Yes. My lord, I appear for 1 and 2, my lord, both the matters.
Yes. We'll take up the matter tomorrow. They will come up for admission tomorrow.
My lord,
My
tomorrow.
lord, actually I am an outstation counsel.
You can appear online. We are permitting.
My lord, I'm really obliged, my lord. Can it be on Friday, my lord? Or maybe on Thursday, online, my lord?
Thursday is okay.
Yes. I'm obliged.
Thursday. Yeah. First.
I'm deeply obliged.
Lordship. Obliged.
The fact that they are asking for first shows that there is no that urgency as stated by.
No, my lord. Actually, tomorrow there I can't come, my lord. That's right.
No problem. See, it is not required that, see, when that facility is available, you can utilize the facility.
But my lord, considering the heat in Guwahati, one would always prefer to come to Shillong given an opportunity.
Yes.
I'm deeply obliged.
Item number 5.
What is the matter about, sir? What is the matter about?
Well, the matter is regarding, actually we are sort of a tenant under the defense land. Now, we are supposed to pay some rent. In the legal parlance, it is
First
called.
order saying that proceedings can go on, final orders alone be.
Yes, yes. No,
No, let the proceedings go on. Final orders can await the orders of the court or further orders of the court.
Yes.
We are not preventing from further proceedings.
If that were the case, because it's concerning the revenue.
That is right. That is the reason why we are not preventing. Final orders, by the time they complete it, you can mention any time, we'll take the matter.
Yes.
The proceedings can go on.
In the meantime, then some deposit has to be made, at least 50% deposit. Because otherwise, the union.
36 rupees a month. Now it has become, my lord, 1,08,000 for 9 months. And my lord, we are not on the contempt, we are on the decision
What
making.
is the total amount involved in this case?
My lord, there are so many, actually one is an association, there are so many members. It would be quite a substantial amount.
What is the substantial amount?
It would be in crores, my lord.
Because it's
My lord, we are prepared to deposit 10% of the demand.
10% not.
My lord, why I'm saying so, earlier it was 36 rupees, now it has been made rupees 1,08,000. So,
25%. 25.
lots of, I think, my instruction is at least 50%, I think, because it's a lot
50%
of
too
money
much.
for 2018 euros.
No, we are not preventing. The letter deposit 25%.
Yes.
That the proceedings can go on. And final orders may await further orders of this court.
yes, yes.
They are not going to prevent. Anyhow, suppose we admit also, they will file a petition, the matter is pending, they will keep quiet. Suppose there is a direction, they will proceed with the matter.
Yes, 25%.
25%.
This number will come. So number you can list it tomorrow. You need not come. This is the order we are going to pass
My
tomorrow.
friend will be there, my lord.
Because lordship may just take us at least 25, can it be enhanced little? Because
No.
my instruction is
My
50%.
lord, we are all hard pressed, my lord. We are all.
We are enjoying paying 30 rupees for 90 years, your lordship. Just
90
imagine.
years.
90 years. That will be taken one day.
25% will deposit, my lord.
30%.
25%.
30, yes. 30%. So I'll also take down.
And no eviction.
Admit, this is tomorrow's order. Admit, notice, the proceeding before the authority can go on day-to-day basis without adjourning the matter beyond 7 working days at any point of time. The final orders shall be kept in abeyance. It is open to both the parties to move this court depending upon the urgency. It is needless to mention that the condition mentioned supra is only on the pre-condition that the appellant deposit 30% of the amount
Of the demand, my lord.
of the demand. This is the order, tomorrow's
And
order.
during the pendency of the case, they will not take any other courtship measure, my lord.
He said other proceedings can go on, but final orders, if there is an urgency, you can move. That's all we have
Regarding
regarding.
eviction and all, they will not take steps.
You deposit the amount first.
I will do that, my lord. In the time.
It will be deposited within how many days?
There should be
My
deposit
lord,
in the period of 1 month.
Within a period of 1 month. Yes.
This will be an order, tomorrow's order. With
I'm deeply obliged.
to the list a number and condown delay. Yes.
Item number
My lord, there will be only one difficulty. My
So
lord,
you
great
can avoid one trip,
My lord, there will be one difficulty.
but you can claim the other fees also.
No.
Yes.
May it please, Your Lordship. This is airport matter, my lord.
Yes.
We have approached the embassy also,
Hmm.
and we have not heard anything, my lord. As of now, my lord, kindly have it on Monday, my lord, 5th August, because
Monday means you will have to say that is next Monday will be the last week,
Last week, yes.
practically last.
or Your Lordship may have it on Friday, my lord.
No,
Friday,
we-
my lord, Friday.
This Friday. This Friday.
Friday, my lord.
We will post on Friday. We'll see. Give
And,
the,
coming
see, we
Friday.
have gone through the report and we have also, we have also prepared the order based on the report submitted by amicus. We do not lose sight of the fact that the expansion project requires huge sums of money to be spent and huge sums of spent and is purely on a policy decision of the government. But at the same time, it is a prerogative on the part of the welfare state and its rulers to provide needs and security to its citizens so as to enable them to live peacefully, and in that event, state itself will flourish and become a state or a state of self-sufficiency. We have to come across an incident which was widely published in the newspaper when Dr. APJ Abdul Kalam, as the president, as then he was, visited Mizoram in 2005, and after completing his official assignments, wanted to leave for Delhi at night, and it was reported to him that it was not possible to take off flight during night hours, and he had to wait till morning. Annoyed by the answer, he commanded for early arrangement to be made to leave the night itself. The officials, having left no other option, lit up the runway with lanterns and flaming torches to take off, to facilitate takeoff. Hence, where there is a will, there is a way. Then there are two types of officials everywhere, and one being optimistic, who will complete the task and making everything best possible with the available resources. On the other hand, being a pessimistic, who will always speak about the negative sides of everything. Unfortunately, most of the public servants having pessimistic characters, as a result of which rulers are dependent on them or misguided and struggling to bring about the welfare measures to the public. The French ruler Napoleon said that the word impossible is not in my dictionary. Similarly, French moralist uttered, nothing is impossible. There are always ways that lead to everything, and if we had sufficient will, we should always have sufficient means. It is often merely for excuse that we say things are impossible. On the whole, in our considered opinion, after having discussion with the officials, we also mentioned about our inspection and of AAI and pilots. It is absolutely possible to land and take off bigger aircraft in the runway having length of 6,000 square feet at Shillong, Meghalaya. See, not bigger aircraft, we'll say mid-size aircraft.
Mid-size.
Change it. The facility which pilots expect from the state government is to introduce visual landing system, proper training, and infrastructure in coordination with the central government. This court expects the state government to coordinate with the central government to find out the possibility to expand the airport at Shillong, which not only fetches income to the state, but also is beneficial to the citizens. This is our detailed order has been dictated. So this is what we are going to release it. We'll see.
Grateful, Mila.
Yes.
Grateful.
You type it and we'll find the order. What do you want to make? Yes. Post on Friday. In the meantime, you confirm. Otherwise,
Yes, Mila. Yes, Mila.
see, 2005, Dr. Kalam has traveled like that. 22 decades have gone by. We cannot go backwards. And so many technology has come.
Yes, Mila.
Maybe, please, your lordship. Lordship permits me. Adjacent there is land, more than 2,000 hectares of land. Sir. So if that avenue can be open, I think the Sadar and all, they want to offer that land.
No, anyway, this is only an interim order. I will not pass final orders.
As your lordship.
It's only an interim order.
Because from 1964, this is keep on going on. Difficult to.
See, you know very well that this is a state where the land belongs to the citizen.
Yes.
And the government will have to acquire. If the acquisition is not possible, then what to do? Now we can try to introduce mid-size aircraft. Then we'll think about a bigger aircraft. That is all.
No, if that avenue can be open, so that.
No, we have not passed any final order. Only an interim order. It's a public interest litigation. How can I close it even without completion of the other proceedings? He has to file. Mr. Mushika will have to file a report. That was not done. Since we have conducted inspection about 2 months ago, I should not forget. See, in the most likely, we may not go travel to Bhutan because they have to give the permission. At that time, I will not be there. My brother will be there. I do not know whether the ex-chief justice will going to sit with him or some other judge. and it will be new to him. So whatever we have done, the exercise we have done for the 10 days, we wanted to put it in black and white. That is all. So there are certain things, I also thought about it. Then I thought I should incorporate the
No,
Abdul
in
Kalam,
fact, that line was served twice. I don't know why the government has done away with it. There's a-
they are doing it. IDAR survey has been conducted. Dr. Moshika said he will file the report. Once
My lord, what happened, my lord?
the report may be in your favor or may not be in your favor.
My lord,
We don't know. Suppose it is
My
in
lord,
your
may I
favor,
submit-
then the question of traveling to Bhutan may not arise, and automatically the airport will be going to be expanded. Now, what we are concerned is what we have seen. What we have seen, because all of us were there, almost very close by to the runway. We were able to see the flight landing, taking off in both aircraft, both the places. So what was seen by us is incorporated in the order. That is all. There are certain things, when you go to a particular place, those days the king will go at night and see what is happening in his kingdom and how the citizens are. Then he will find out the problem. Then the next day he will give the solution. Similarly, judges will want to go to this site, place. See, in India, there are a lot of encroachment in all places, Delhi, everywhere. If the encroachment need to be removed, sitting judges will have to visit. Take the plan, see the layout, you can give quite the entire matter. Otherwise, you will appoint a commissioner, then a report, then an argument. 10-page document will become 1,000-page document. You may not know which to refer, where to refer.
Yes.
Single judge will pass one order. In some cases, division bench will pass different order. The Supreme Court may pass different order. See, the Supreme Court has come down heavily in the Kerala encroachment in water bodies.
Yes.
Completely, both the buildings were demolished. See, all these things and all, public interest litigation, more so, I feel judges should not be dynamic. Judges should be dynamites.
It requests.
Only then there will be solution to the problem. Otherwise, there will be no problem at all. When you want to do something good, go ahead.
Oblige.
Everything is 2020 match. Yes.
Deep-